Hello and welcome to the Parent Advocate Network hosted by the Coalition for the Protection of Children and Families. My name is Lyra and I will be your host tonight. We have a special guest tonight and Nij will introduce him. It's John, I'm sorry, I forgot his last name.
Gentry.
Gentry, John Gentry. Thank you, Nij. And Mim, welcome. Thank you for joining us tonight. And we're going to have a great meeting tonight. Thank you. First, I would like to ask everybody to please, when we have these meetings, look professional. You know, have a clean environment or at least a clean wall for people to look at. Please, no smoking, no swearing, and no disrespect. We are here to share our ideas and our information and understanding of the way things are, which, quite frankly, is not the way things should be. And, you know, we all have common ground here and we can all share our understandings and hopefully expand the understanding of other parents, families, citizens of the world, about your rights and your responsibilities in being a member of society today. And so I thank you all for joining us tonight, and anybody who watches our meeting is welcome to join us. We meet every Saturday at 7 p.m. Pacific time, which is 9 p.m. Central and 10 p.m. Eastern, right, Nij? All right, and we are covered all across the country right now with everybody. This is great. And so, Nij, would you like to let our members know a little bit more about John Gentry before he joins us tonight?
Sure. I was just giving him the number. John, he's originally from Maryland. He graduated from College Park, which is one of the state best college in Maryland. Hi, John.
Hey, how are you guys?
Yeah, Lyra is here.
Yeah. Well, I look like crap. I've been working all day, so you'll have to pardon.
Hi, John. This is Lyra, and thank you for joining us tonight. I am the host of the Parent Advocate Network here, and we are very happy that you are here to join us. Nij was just introducing you. If we could allow her to continue.
Thank you. I'm really impressed with John. At only one strike of my request, he taught me how we have to think about beyond my case. We all are talking about constitutional rights. We are talking about deprived rights, everything. But we need to look at the bigger picture. With the bigger picture means the whole USA stays with me when John, when Lyra, when Mim, and everybody thinks the same thing. And I start working on my state level because I cannot help you from California, from Maryland to California. So John has introduced me different ways to fight in. It's not the fight as a war, how we use our keyboard skills to make attention in the court. And John has been, I call it successful so far because I got all dismissal, but I'm still there in the system. I'm still filing complaints. Let's hope somewhere I can get in. And I'll let John speak about, because I don't want to say something where people, can make it subjective. Instead of that, let's him introduce his background, where he was and where he is now in the system. So John, please help us.
So I think probably the reason that we're all here is because we've suffered injustice, and we've gone in front of judges that are corrupt, that don't honor the rights guaranteed in our Constitution. They take our property, they deprive us of our children, and that's the heart of the problem, and that's where we need to attack and get away from working on our individual cases and attack the system. I think when you appeal and try to go federal with your individual case, they don't want to hear it. And the federal courts are not interested in hearing about divorce cases, and they just say, we're not interested. We don't care. And it's clear to me that even the federal courts, the district court, and even at the circuit court level, are not interested in enforcing constitutional rights in state court proceedings. At least in the Sixth Circuit, it's for sure. They will not enforce constitutional rights. It's very disappointing. So how do you fight back? And I think it's going after the system. And I think where I hope to find success, it's true in every state that they've enacted laws that are unconstitutional with the single decipherable intent of protecting corruption. That's how they've been able to perpetuate this problem, is by putting statutes into code that says, well, you can't sue us, we're immune, you can't do anything about it. And most people look at it and they say, oh, well, there's this statute of limitations, I can't sue them, or there's this immunity or that immunity and I can't sue them. Attack the law. The law is unconstitutional. And when you take it out of the realm of your individual case and you start attacking the system, I think then they got to listen. You know, when you say, hey, this statute is clearly unconstitutional, then how does the federal court say, no, we don't want to hear that? And then you say, this unconstitutional law is what caused these things to happen to me. So that's a really great way, and I'll give you guys some examples. I'll share my screen with you, and I'll show you what I'm talking about and how easy it is to identify laws that are unconstitutional. How else do we fight back? Every state has a judicial oversight agency. In Tennessee, we have Tennessee Misconduct. I'm going to share my screen with you guys and show you an analysis I did. This was actually out into U.S. Congress in another case. Can you guys see my screen? Okay, so this was I'm a CPA, so this was an auditor's compilation report that I did. And I looked at 18 states. I just picked them random. I was on a short deadline for putting this together to go into this brief to Congress. And so I just stopped at 18 states. I did a couple more states down here, but they do not make them available online. So these are annual reports from these judicial oversight agencies. And you can see overall there's a 95.5% dismissal rate, which is appalling. And when you go look at the 4.5% or less that they actually do take action on, it's only when it's filed by a legal professional. It's when there's infighting between these corrupt bastards that they'll actually do something. But when it's somebody trying to protect their rights, they just dismiss the case. And I mean, Connecticut, they literally dismiss 100% of the cases. It's like, why do they even have a judicial review council? Because they don't even look at anything. It's a waste of taxpayers' money. But this opens the door for us. When they only act on complaints filed by legal professionals, that's an equal protection violation. It's discriminatory. They're only acting on complaints filed by a distinct class of persons who happen to be legal professionals. Everybody else who's not a legal professional, they dismiss. And that's your in to say it's because of this Board of Judicial Conduct not doing their job that my rights were violated. And then you can seek redress against the state for that. That makes sense to you guys? So, and trust me, they're going to fight you hard. And the district courts are in league the federal district courts are in league with the state courts. And the federal district courts, there are a few of them out there that are not. I don't know if it's appropriate to say they're in league or they're corrupt, but they're so biased in favor of judges that they won't enforce the Constitution against a brother or sister who wears a robe of justice. I kind of think that it's corruption, and certainly in my case, the magistrate judge was extremely corrupt because in that case, and I'll give you an example here. Are those red lines from me? Can you guys see that on my screen? You don't see them? I don't know, it looks like scribble across my screen. One of the things that I do is I kind of try to, in federal court, I set them up to fail. I know what they're going to do. And so I'll just submit something just to get a reaction from them because I know that the district court is going to violate my rights. And so I'll kind of set them up for that, and that's going to get me evidence down the line. And I'll give you a good example of that.
John, is that the norm across the board in the states?
I didn't understand. I'm sorry.
Is that the norm, the status quo across the board in the states? That they're going to violate, you just expect it? Is that what you're saying?
Oh yeah, I totally expect them to do it. I know that these guys, I know that they want to protect judges, and I'll get into that a little bit more in a minute here. Oh. But I want to give you an example of the challenges that you face in federal court and how they will try to trick you, actually, try to dupe you to get you out of federal court. So I had filed my complaint, and under the federal rules of civil procedure, Rule 15A1B, you can amend your complaint, and you don't need permission from the court. Whenever they file it's a 12B motion to dismiss, and they say, oh, you failed to state a claim, so you can't sue us. And you have 21 days after that, you can amend your complaint. So I got a 12B motion to dismiss from the state of Tennessee, and I said, hey, I'm going to amend my complaint. And I also need to file a response to the motion to dismiss. So I filed a motion for extension of time. And I actually thought that what they were going to do was just deny my extension of time, which I was going to complain was unfair because here, this was the opposing counsel, state of Tennessee, requested an extension of time, and they just stamped it at the top and said, great. Gave them an extension of time.
It's the silvery colors.
What's that? Okay, so I thought that it might give me an opportunity to show that they were biased by dismissing my motion for extension of time, but they actually did one better. So you notice on the state, they did a motion to dismiss, and they just stamped it and signed the judge's name. It was a magistrate judge. When I filed a motion for extension of time, I asked for two documents. I want to file a response to a motion to dismiss, and I want to amend my complaint. And I was very clear. I said it twice. I want an extension of time for two documents. And so the judge came back, and instead of just granting my motion like they did for the state, they came back and they said, presently pending is this, da 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 da. And they said, plaintiff shall have it to file a response to the motion to dismiss until March 31st. Well, I asked for two documents. Why did they only do one? And what the intent of the court was is that I would file both documents, the amended complaint and the response to the motion to dismiss. And they would say, oh, sorry, you filed your amended complaint too late, and so we're not going to accept it. They were trying to dupe me, is what they were trying to do with this, which is really sad. But that's exactly what they were trying to do. Why didn't they just stamp my motion?
Nidge wanted to know, what is the rule to amend the pleading, John?
So it's under Federal Rules of Civil Procedure, Rule 15A. It's Rule 15 deals with amended pleadings, and 15A1B says, as a matter of course, you don't need permission. So when you file a complaint and they come back with, and they're always going to come back with a motion to dismiss, and they're going to say your complaint is defective for reasons A, B, and C, and you can't sue us. And so then you have 21 days, and you can go fix your complaint and say, well, no, you can't get rid of me for reasons A, B, and C. And you don't need the court's permission. You can just do that. Now, if outside of that 21-day response to a motion to dismiss, you have to request leave of court to amend. And that's under Rule 15 also, I believe. And in that case, the court should freely grant leave to amend so that justice is served. But in our cases, they often don't. But when you guys get that far, I can help you with that. Just to go on further, so I expected when I did my motion for extension of time, and this judge came back and only granted me an extension of time on 1 document. When I asked for 2, I filed a motion for clarification. And I said, hey, I asked permission to file 2 documents, but you only gave me permission to file 1. And so the judge came back and said that my motion for extension of time is granted, and I can file my amended complaint and the response to the motion to dismiss, both 2 documents. And then she said, in light of this extension, plaintiff's motion to clarify is denied as moot. So it must be obvious. Do you guys see that? Like, why didn't she just stamp my thing like she did that for the defendant? She was trying to trick me, you know. And that's the challenge when you go into federal court. Another example of the trick that they try to use. Not every district court, but many of them have magistrate judges. A magistrate judge is below a district court judge. They cannot decide with finality any case. Magistrates are there to just help the district court judge and facilitate the process. In their terms, they cannot decide on dispositive matters. Dispositive, deposed, they can't get rid of you, or they can't do a summary judgment and say you won. They're just there to facilitate the process. But what they do is the magistrate will make a recommendation. It's called a report and recommendation to the district court judge saying you should dismiss this case. Now the trick there is that if you do not object to the magistrate's R&R within 14 days, then you're done, and you cannot take it to the Court of Appeals after that. And so you have to object within that 14-day period. If you don't, when you get to the appellate court, and so you appeal from the district court to the U.S. Court of Appeals for your circuit, the circuit court will look at it and they'll say, well, you didn't object to the magistrate's report, and you cannot skip the appellate process. You should have gone to the district court judge first. And you can't skip the district court judge and come to us. So sorry, we're not going to look at it. You're done. And that's a trick that they use, and most pro se litigants don't know that they have to object within 14 days. Like, you really got to dig through the rules. That crap doesn't work with me because I'm a CPA and I read the rules. And so I've kind of learned all of these little tricks, and there's a lot more tricks that they can use, and we can go more into that. So when you go into federal court, the first thing is to learn the federal rules of procedure. Find somebody like me. I'm happy to help anybody who's working on reform, by the way, and understand the tricks that they're going to use to try to get rid of you. The next thing that I alluded to earlier is when you're filing a complaint, if you're just saying my rights were violated, you're not going to get anywhere. You're just not. They don't care about family court cases. So you have to bring in other causes of action to substantiate your case, to make it worthy of federal court intervention. And so that's where, going back to this auditor's compilation report. So how you set up the facts to create a viable claim against the state, file a complaint against your judge. Let me give you a quick example here of how to do that. So you go on Google, and I'm going to look for Tennessee Board of Conduct. So every state has some kind of judicial oversight agency. They go by different names. Alabama Judicial Inquiry. You guys are out. Are most of you guys out of Maryland? No? Where are you from, Lyra?
I am from California.
Okay, so California's on here. It's the Commission for Judicial Performance.
And Pennsylvania.
And there's people all across the country here that are tuning in tonight and also going to be watching this later on our website, coalitionforprotection.com. So
Sure.
Thank you so much for this. This is wonderful that you are here to talk about and explain our rights and how to file claims in federal court. Thank you.
Sure. So, so setting up the facts in your case and creating a viable cause of action, because they are not going to care about a divorce case. So you have to add some validity to your cause of action. So file a complaint against your judge. In California, it's the Commission on Judicial Performance. In Tennessee, we have the Tennessee Board of Judicial Conduct. And here they have a big link, file a complaint about a judge.
Well,
what's that?
I'm going to say this. I was down in San Francisco at the beginning of January to meet with the rest of the members of the Family Rights Party. And we went to a judicial council meeting where they were discussing creating more accountability in the family courts, right? And parents were coming up testifying about how their rights had been totally violated in front of this judicial council. And the judicial council, one member was actually smirking and kind of chuckling when a woman was passionately telling about how her child had been found in the forest 7 days after the judge had given custody of her child to the father who was abusive and had shown that he was abusive, and the boy was dead. I believe it was a boy, yeah, and all she had left was her urn of ashes. And there was one of the judicial council members that was giggling. And we've been protesting here in California because judicial council here in California doesn't do anything. So I mean, there is a lot of frustration on that level too.
That's the point. We expect them to do nothing, and we're at least gonna raise a stink about it and evidence it in the record that these guys are corrupt and they don't do their job. And I would be, if anybody wants to go this route, I'd be happy to send you this report that you can file in your case. It's been filed in the United States Congress, it's been filed in cases down in Texas and Utah. So this report has gotten around. And I think it's because of this report. In Colorado, this is just totally aside here, but in Colorado, on judicial discipline, in Colorado decides, oh, this is worthy of investigation, then it becomes a complaint. And so Colorado has a 96% dismissal rate, and overnight, with a change of that rule, they're going to have a 100% take action rate. Just by changing the rules. So getting back to how do you set up your facts for your case to have something that's more valid. So file a complaint against the judge, knowing that they're going to dismiss it. then you file something like this report in, and you say, well, they dismiss all complaints. They only act on complaints filed by legal professionals. And when you go on their website, I'll give an example of mine. By the way, these annual reports. That's where I put this together. I use their annual report to put together this analysis.
It looks gross.
But here they have, click here to view public disciplinary actions. Can you see it on my screen? Yeah. So when you look at those, you can read these things and you can tell that it's obviously the complaint was filed by another judge or a legal professional or a courthouse worker. They will never act on a complaint filed by a non-legal professional, which is discriminatory, and it's in violation of the Equal Protection Clause of the 14th Amendment, which gives you standing in federal court. There's a case, Pacific something, that says it's not whether they should have acted on the complaint, it's the barrier. And that barrier gives you standing in federal court. And so the federal court will likely be in league with you, with the state, and they'll probably dismiss you anyway, but it gives you a good, strong, appealable issue to take the appellate court, and maybe they're not corrupt. And if they decide against you, then you still have an option to go to the Supreme Court. Now, this is not, so when I talk about setting up the facts for your case, now you're not talking about just a stupid divorce case. You know, you're saying this is a system where they do not enforce, they do not provide any oversight. And because the state doesn't provide any oversight, that's why my rights were violated in divorce court. That's why I wasn't allowed to present evidence or present arguments, or why they took my kids away from me without probable cause, or whatever it is. Now, do you see how this becomes more interesting now? Because you're looking at the system and you're saying that they're not providing oversight. That's one example of how you can strengthen your case in federal court. Let me give you another one here. Sorry. I said earlier, every state has enacted statutes that are unconstitutional, right? And these statutes were enacted with the single intent of protecting corruption. And I'll give you an example. And I actually was on the phone last night with a guy from Arizona, and they have the same crap in Arizona. Sorry, this document's so big. Here's 7A. All right, so in my Tennessee code annotated, and you can find this in your statutes, and we found almost this exact same language in Arizona. And so the title of the statutes are extremely misleading. It says removal of immunity for injury caused by negligent act or omission of employees, exceptions, immunity for 2,000 computer calculation errors. What the hell does that mean, right? It says removal of immunity. So you're thinking, oh, good, they're taking away immunity. I can sue them, right? They come down and they say immunity from suit for all governmental entities is removed for injury approximately caused by negligent act or omission, except if the injury arises out of. So they're not taking away immunity. They're giving immunity, and it's unconstitutional. So they're saying, well, we have immunity for false imprisonment pursuant to a minimus of a court. Do you know what that is? That's when they hold you in contempt and the judge puts you in jail. False arrest, malicious prosecution, intentional trespass, abuse of process, libel, slander, deceit, interference with contract rights, intentional infliction of mental anguish, invasion of a right of privacy, and civil rights. They're saying you can't sue them for these things. That's unconstitutional. It's repugnantly unconstitutional. You cannot grant immunity for suit for civil rights violations, nor can you do it for an invasion of the right of privacy. Those are constitutionally protected rights. This law is, it's just I mean, I was astounded that these guys got this in there. Now, my state constitution says the oath of office, and this is similar across other states, the oath of office is included in our state constitution. And it says, you know, I, Joe Legislator, do hereby solemnly swear that I will not propose or assent to any law that lessens or abridges the rights of the people. What the hell does this law do? It lessens and abridges the rights of the people. There's another one here. So this one is astounding to me. And again, the title of the statute, and you can probably find the same thing in California, because all these guys work together and they say, hey, we need to protect ourselves from our corruption. So here's this law that we enacted in Tennessee, and you guys should do the same thing in California and Iowa and wherever. So personal tort actions against certain professionals. So this certain professionals, like that's got to clue you in. That's it. That's in violation of the Equal Protection Clause. What about other professionals? Why don't they get this protection, right? And I'll explain why that piece is in there. But it says the following action shall be commenced within 1 year after the cause of action. Civil rights actions for compensatory or punitive damages brought under the federal civil rights statutes. So Tennessee has enacted a statute of limitations for federal law. They don't have that authority. Congress, U.S. Congress, has authority to enact a statute of limitations for federal law. The federal government never granted that authority to the states. Does that make sense to you guys? Like, they can't do that. That's unconstitutional. So how to strengthen your case? File a complaint against the judge. When it's dismissed, file a complaint against your judicial oversight agency for failure to provide equal protection. Then you attack these laws and you say, you know, this law right here caused what happened to me in state court. This law is unconstitutional, and it was clearly enacted to protect corruption, to protect civil rights violations, which includes the right of due process. Does that make sense?
Yes, yes, it does, John. I do have one question, because one of the things that I have been investigating, being a victim of domestic violence and being disabled, is that the Social Services Department, CPS, used my disabilities against me, and they do this in a lot of cases. And I found that there are actual laws that each state, or most every state, has enacted to discriminate specifically against parents with disabilities. So would that then be another one of those violations of constitutional rights to put on this complaint?
So you challenge the statute and say, you know, and that gives you standing, because now, you know, you're not just going in there saying my rights were violated. You're saying my rights were violated under unconstitutional state statute. And how does the federal court say, you don't have a valid cause of action. We don't want to hear that.
Right.
And then that gives you standing to go to the circuit court and then and very likely you're going to find that the circuit courts are corrupt as well. And it's really hard to get into the Supreme Court just because of the rules and the filing procedures and everything they have in the Supreme Court. To give you an example, under the Supreme Court rules, let me jump over it real quick.
But what you're saying is that everybody needs to follow the process going from the county court to the Supreme Court of Appeals to then the state Supreme Court and on up the chain, but we also have to file complaints with the Judicial Council Committee.
Yes.
And I mean, a lot of people are talking about filing complaints with the FBI, with
The
Department of
FBI.
Health and Human Services, all those things.
Have you watched the news? The FBI is corrupt. I've called the FBI 5 times. I have tons of evidence that these guys extorted me under color of law. They engaged in witness tampering, subpoena evasion, which are all federal crimes, and the FBI won't even look at it.
My psychologist reported to the FBI about my ex-monster, and it didn't go anywhere. He's a criminal informant, and his family is the police in Kansas, so he has quite a bit of asset liability, I think, to them.
Okay.
But when reaching out to local law enforcement as well as state, and even making complaints with the Judiciary Committee in Kansas about his lawyer, nothing's ever been done. My psychologist reported a lot of things that he should have been investigated for, and it was just blown off, and they blew me off, and so.
So here's why the Supreme Court is so difficult. Unless you have been determined as in pauperous status, that you can't afford your own counsel, that you can't afford court costs, and that has to be determined by a lower court before you can use that at the Supreme Court level. And I'll tell you, probably the Supreme Court level is the only level you're going to get any relief, and only then because you're including causes of action against unconstitutional statutes and against equal protection violations by these judicial oversight agencies. But so this is the Supreme Court rules, Rule 33. You have to do 40 booklets. I'm going to take you off a screen share here and show you what one looks like. So this is a blank booklet that I prepared. You got to do 40 of these for the Supreme Court, and this is called perfect binding. So they're glued in here. I actually got, you can see it in the background over there. I have a binding machine to prepare these. Let me go back to screen share here. So you have to do 40 of those booklets, and then I think somewhere in here, I can't remember off the top of my head, but you got to do 3 or 4 to each opposing counsel. And so you got to do like 50 of these things. And that's cost prohibitive for most people. I'm very resourceful. I bought a machine, figured out how to do it myself. I'm going in under veteran status, and so I'm hopefully going in under Rule 33 down here. 33 you can file on 8.5 by 11-inch paper. 33.2. So under 33.2 you can file under 8.5 by 11-inch paper. But if you don't qualify for impauperous status, or if you're not a veteran, then you have to go with those 40 booklets, and that's like almost impossible to afford. I checked around with a couple of printers that specialize in doing Supreme Court briefs. It's like $8,000 to get those booklets prepared, and that's how they just keep people out of the Supreme Court. and protect all of this corruption that's going on. But if you know, to be honest with you, that's the only way I think that we're going to fight this thing and find justice. Individual cases are not going to be heard.
Right.
It's only be heard if they're attacking these judicial oversight agencies and you're attacking unconstitutional state statutes. Then I think they kind of got to listen. And then it's a hard fight after that.
So what do you think could be done as far as legislation? Because as Secretary of the Family Rights Party, it is an interest of mine to be able to share information that can help change laws so that we can get, you know, this is a broken system we're talking about here. And it doesn't matter what level of civil law you're in, you're getting screwed. And I can't use any more verbal language than that. So, you know.
The legislature will do nothing.
No, laws. I'm not talking legislatures. I'm talking like, you know, with the Family Rights Party, what we want to do is promote legislation that's going to be in alignment with family rights and as fundamental rights and stuff like that. And so, you know, what do you think in the judicial sector would need to be presented for such an endeavor?
You know, unless we can get, I was trying to find, I have a list of about 40 legislators who are on the Judicial Committee, they're on Ethics Committee, any committee at the state legislator level that is remotely related to reform. I copied them on. I'm trying to find it here. No. But anyway, so I emailed these guys. They just don't care. And finally, when I emailed them a copy of my Supreme Court brief, I got a response. And that's what it took just to even get them to respond to me, was to send them a copy of my Supreme Court brief. I want to give you a quick rundown on what's happened, why we are where we are, just for a historical perspective, so you guys can understand why all this crap is happening. This is a motion to disqualify every U.S. Supreme Court justice that I filed into my case, which is kind of going to piss them off, I expect. But I did, a motion to disqualify each of them. One of the sections that I put in here is brothers and sisters of the robe. In a New York Times article, I think it was Senator Sass, when Justice Gorsuch was getting nominated by President Trump, when they go through that nomination process, the justices go meet with various senators and representatives, and they just kind of have a one-on-one. What are your beliefs? And they're trying to get a feel if they have any issues with this particular judge being nominated to the Supreme Court. And so this Senator Hass asked Gorsuch, what do you think about Trump saying that the Ninth Circuit, a high school student, could read better? Did you guys hear about that in the news from the immigration ban? No? So you guys heard about the immigration ban. President Trump banned like 9 countries from allowing anybody into the country. You guys heard about that, right? So the ACLU filed a complaint. They named President Trump as the defendant, and they said this immigration ban is unconstitutional. And at the district court level, and then in the Ninth Circuit, they upheld it. And they said, yeah, you can't do that. And so President Trump came back and like, well, the Constitution gives me authority to do it. It's right here in the USC. The United States Code gives me authority to do that. And these guys didn't even read that. They didn't even respond to that argument, which is very typical of judges. If they don't have a response, they don't address it. And that's how they ignore the issues and how they dismiss complaints. So they didn't even address the fact that the president has authority to do that. And they stopped his immigration ban. And Trump came back and said, well, a high school student could read better than these guys. So the senator asked Gorsuch about that. And he said, it's incredibly disheartening to hear things that might undermine the credibility and the independence of the judiciary. And he further said, any criticism of his brothers and sisters of the robe is an attack or a criticism on everybody wearing the robe as a judge. And
that's what I was just laughing at that, because it's like he did the flip-flop right there in the whole speech, didn't he?
This is the heart of the problem here, is that these guys protect each other. And now it's just gotten so bad that these guys can do whatever the hell they want to us. True story, just happened in Arizona. A social worker went to a lady's house and said, I need to see her kids. I need to see that they're safe. And she's like, you got a warrant? And he's like, no, I don't. And she's like, well, you're not coming in. So he took her to court, and he said, she must have murdered her children because I can't see them. And the judge arrested her on the charge of murder. I shit you not. Like, no proof, no bodies, no smoking gun, arrested this woman for murdering her children, which is total false arrest and malicious prosecution. But because...
John.
Yeah.
I didn't mean to interrupt you there, but I just wanted to say myself to kind of relate to what you were saying. In my story, it was kind of the same thing. They come to my house and ask to see my kid, and I said no, because my kid was in school. They should know this. And because I didn't let them see him, they said I was doing something wrong. They accused me of shooting her with a damn paintball gun that I don't even own.
Well, we can go into a whole nother discussion, but
I know we could. I know we can.
But how I fought these guys, and I've been pretty successful. They tried to extort me for $188,000 of my ex-wife's attorney fees, and I was like, you can't do that.
Are you serious? That's just messed up.
And then they tried to get me for like another 50, 75 grand in the appellate court. And I beat them on it. And that never happens. They always...
Absolutely not. I'll tell you what, I must say why before I mute you again so I can let you finish your story. I'll tell you what, you have my head spinning with your knowledge. I definitely need to get in contact with you. You know what, I thought I knew it all, but you know what, I'm learning some more now. Hell, I'm never done learning. Knowledge is power.
I'm still learning too, Thomas.
Awesome. Thanks, John. Appreciate it.
So I made the argument, like, how possibly can you guys in the Supreme Court hear a case where I'm challenging the entire legal system of the state of Tennessee when you have this belief? And so you have to disqualify because you can't hear this case fairly. I found another case. It was just filed on December 8th, and this one was really good. This lady evidenced in the record, is it here? No. Yeah. This is Supreme Court case number 17526. The justices and the clerks that assist the justices are all members of the American Inn of Courts. And the American Inn of Courts is a fraternal organization that brings together, and you can go to their website. It's to bring together everybody from law students to the Supreme Court justices, to bring them all into the same fraternal organization, the same room, to socialize. This is a huge, huge problem that these guys participate in that. Beyond that, there's huge conflict of interest because the American Inn of Courts paid for $7,000, $8,000 European vacations for the clerks that support the justices. And so now you've got this relationship between the Supreme Court and legal professionals, these guys that are being heard in the district courts and the appellate courts. And they, now with that relationship, it's real easy for them to get together and say, hey, make this one go away, or don't grant cert, So I said, I argued in here, there's this huge conflict of interest. This one astounded me. Supreme Court opinions suggest a change in due process enforcement. So there was a case, this case Caperton v. A.T. Massey, was a judge that was receiving donations for his election, and it turned out that one of these donators was a defendant in a case, and the judge was obviously biased because he's getting money from this person, right? This guy, Chief Justice Roberts, he's our present Supreme Court Justice. He said, the end result will do more to erode public confidence than the judicial impartiality than the isolated failure to recuse in a particular case. What he just said is that false public confidence is more important than justice. That's a big frickin' problem right there. And I put it into my document, intending no disrespect. The statement of Chief Justice is that public confidence is more important than justice. Scalia, who passed away recently, he echoed that same thought. Justice Roberts went on, he said, I believe opening the door to recusal claims under the Due Process Clause for an amorphous probability of bias will bring our judicial system into disrepute and diminish the confidence of the American people in the fairness and integrity of the courts. But people don't have any perception of fairness and integrity anymore. That we all know what's going on. The only people that don't know are the ones that haven't been to court yet.
Yeah. Oh, hold on, John. I think Thomas wanted to ask something. Thomas,
Sure.
did you had your hand raised? Did you want to ask a question?
Yeah, I was just kind of put a piece of information, but I'm sure John already knows. But some other people might not know. But anytime anybody goes into court, if you guys don't know this, right off the bat, really, if we wanted to fight it, it is a conflict of interest on any case because, when we file an appeal, we pay for that. So therefore, they're going to take it because that money benefits their retirement. So really, that people need to see that is a conflict of interest if we really pushed it. And that's why they push it so much, because the more they push it, the more they get paid towards their retirement. So they have their hands in for the money.
Of course. That's what this whole thing's about.
Follow the money trail. Follow the money trail.
Well, what am I doing wrong then? Because I thought I was working all the time, but apparently I ain't getting as much as they are.
So I'm gonna jump off of this point real quick, but there's an important point I wanted to make. So both Scalia, who just passed away, replaced by Gorsuch, and Chief Justice Roberts are saying public perception is more important than justice, and that these recusal issues. And by the way, I've asked like every single judge to recuse, and none of them would do it for the single purpose of continuing to violate my rights and extort from me. When you compare
RICO violations, right? This boils down to RICO violations, doesn't it? When they extort you?
oh, that's what my case is RICO, reform, and civil rights, all
Okay.
of those. But when you go back to 1955, the Supreme Court said a fair trial and a fair tribunal is a basic requirement of due process. Every procedure which would offer a possible temptation to an average judge not to hold the balance nice, clear, and true between the state and the accused denies the latter of due process of law. But to perform the high function in the best way, justice must satisfy the appearance of justice. And I closed it off and I said, you know, these earlier Supreme Court opinions compared to the more recent opinions suggest a shift in opinion about the essential elements of due process. And it's because these guys are all protecting each other. To understand, well, it's a long, it's kind of a long dialogue about what happened to the legal profession and how we got where we are right now. Maybe we can do that in another meeting. I don't want to kill you guys with that because that's like another 40-minute dialogue.
Thank you, John. This is awesome. You've been very informative and helpful in helping us understand some of the issues that we are facing in this country with regard to politics and policy and judicial corruption. And it's very important that we learn this in order to be able to find ways to change it and to get our rights back. And I wanted to just say one other thing. I'm sorry, I do apologize, but Nidge was asking with Rico, can she do a joinder? Hers was denied.
Rico, let me show you my Rico complaint. There's a lot of elements to doing a successful Rico complaint. It's very hard to do. All right, you guys see my screen here? So this is my Rico complaint, 103 pages, just for the complaint. And I'll tell you about some of the essential elements of doing a Rico complaint, just real briefly. Just as an aside, when you file a complaint in federal court, you are not going to get an evidentiary hearing, and you are not going to be allowed to present evidence because the federal courts are going to do everything they can to get rid of you. They're probably not going to let you amend. They're not going to grant leave to amend. So your only chance to amend is a matter of course under that Rule 15A1B. 21 days after filing or within 21 days after getting a 12B motion to dismiss. After that 21 days, they're not going to give you another chance to amend. So it's critical that when you file the federal complaint that you include your evidence along with the complaint. And I'll show you an example of what I did with mine. This is my filed copy. The Word document we're just looking at is my Word copy of it, but this is the one that was actually filed. And in this document, you'll see I have the orders attached as Exhibit P. So I'll make an allegation, and then I'll say, here's the evidence to support my allegation, because I know I'm not going to get an evidentiary hearing. And without being allowed to present my evidence, the Circuit Court of Appeals is going to go, conclusory, unsupported, no evidence to make these claims, dismiss. So you have to put your evidence into your complaint. And so this is essential. Chris Hallett shared this with me a couple of years ago, and I would not be where I am in federal court if I had not included my exhibits. And so here's exhibits A through W attached to my complaint, which is 242 pages of exhibits that I filed along with my complaint. And that's just necessary because you're not going to get a chance to do it otherwise, and they're going to dismiss you as conclusory.
So I did an excerpt of each of the like discriminating statements in my complaint when I filed a request for administrative review with the state Supreme Court. Can I do that same thing in the federal court? Because I was denied.
Yeah, here's some of the essential elements to doing any complaint, but particularly doing a RICO complaint. Gives the judge or the magistrate a summary of the case and say, here's the nature of the case. So mine was at its core, this is about the corruption of the state's legal system at all levels. And then I went through it and spelled that out. Then you detail your parties. Say, here's who I am, here's where I live, here's my address, here's my phone number, here's one defendant, here's where their office is located, here's the other defendants. Then I'm going after the state of Tennessee. So state of Tennessee is a political subdivision of the United States of America, one of 50 several United States, Then you have to state your jurisdiction and venue. That's saying that these are the federal laws that I'm complaining of, and under Article 3 of the United States Constitution, this court has jurisdiction. So you spell out jurisdiction. Then you do general allegations, and this is common to all of the defendants in the case. Now, in my general allegations, because I'm doing a RICO in this case, I had and this is unique to my case, I had a patent pending product that I distributed internationally. I had distributors in the UK and Australia. I sold to almost every country across the globe. And under, let me jump back here a minute. There's a lot going on with this stuff. This is a really good resource that I like. It's Cornell. So if I type in 18 USC 1964, so that takes me to Cornell. And if I go under Chapter 96, this gives me all of the RICO statutes. And so Section 1961 defines racketeering activities. And to do a successful RICO statute, 2 or more of these things had to have occurred within a 10-year period.
Are you aware that the screen was just showing up with advertisements? I didn't know if you were aware of that.
It's showing up with advertisements?
It was for a moment there. I apologize. And now it's showing up with temperatures.
Temperatures.
And now we've got the definitions. I don't know what happened.
Let me reshare. Thank you. All right, can you see it now?
Can't see anything now. Oh my.
Let me stop it again and reshare. What?
It's a blank screen as far as I can tell. Anybody else see something different?
No, blank screen here too.
Oh, wait a minute. Here we go. They're coming up. All right. You got them. Okay, so you were talking about these chapters for.
Yeah, let me get back. I went back to the beginning.
Okay,
It might be you are lagging
it,
behind me.
it could be.
Okay, so now I have up 18 USC 1964. Are we on the same? You behind me a little bit?
And it's coming right up here. But that I'm sure it's yeah, okay.
All right, so now I'm going to click on chapter 96. And so 18 USC chapter 96 is all the RICO statutes. You guys see that?
Yep.
Okay. So 1961 defines the racketeering activities. And so there's extortion, witness tampering, subpoena evasion. There's a big laundry list of what are considered racketeering activities. So this is step one. For RICO, you have to have at least 2 of these within 10 years. Okay?
Okay.
1962, section 1962. This is really important. And there's 3. You have to satisfy one of these 3 things to do a successful RICO. So it's unlawful for any person who has received income directly or indirectly from a pattern of racketeering activities. So that's 1. Number 2, it's unlawful for any person through a pattern of racketeering activities or collection of unlawful debt to maintain any interest or control in a racketeering enterprise. And then the 3rd one, it shall be unlawful for any person associated with an enterprise which affect interstate or foreign commerce. And that pertained to mine because I had interstate and foreign commerce. Okay? So this 1962 is actually the hardest part to satisfy in a RICO claim, is satisfying one of these 3 things under RICO. And as part of this, they don't say it in here, but the Supreme Court has ruled that there has to be a threat of continuing activity. Not that it just happened, but that there's a threat that it's going to happen again, that there's a threat of continuing activity. And that's an essential element to a RICO claim. So in mine, I had an easy one here because I engaged in foreign and interstate commerce. I'm automatically good under 1962 subsection C. You follow? But this one, and I'm not going to go into this too much, but investment in income. So I allege that the attorneys who extorted money from me, that they reinvest in themselves, and that there's a threat of this continued process. And here's a good way to explain it. So I said, in analogy, consider a business person who starts a business providing services. Could be anything, plumbing services, stockbroker services, doesn't matter. Assume that this person must hire an employee. To pay that employee, the business person would have to invest cash in the business starting out to pay for the employee. The same analogy applies to the defendants in the case, and they continually reinvest the proceeds from their racketeering schemes back into themselves, thus establishing a racketeering enterprise. The district court, she didn't like this argument, but we'll see what the appellate court says. And then there was another one here.
Would what Thomas stated earlier regarding the whole appeal process that we have to pay to file an appeal and everything, wouldn't that be also considered racketeering, like that, to begin following the money trail that way?
No, this is like, so in here I said they get kickbacks. Maybe it's you win this case, I get to win the next one because they're when you go into a court, my own attorney conspired against me, and the whole purpose of it is to generate billable hours. And what they always do is they typically side with the party that's wrong, the party who's causing harm to the other party, knowing that the person that's in the right is going to keep fighting for justice and keep coming back. And that's how they drum up that's how they keep the litigation going. That's what it's all about. Let's go back.
John,
Yeah.
it's funny that you say that. When I filed mine, now mine all started, I had like 8 or 9 different allegations that I had to fight. And I won them all. So when the newest one come around, I fought it. I had to take it all the way up to the highest. And I'm still getting ready to file a brief on it now. But my evidence was 138 pages long. I just got the letter. That's why I have to file.
You just got what? Say that last part.
Hold on, Thomas, you got muted somehow. Let me unmute you. I'm trying to unmute him. Thomas, are you there? Hello? You got muted. There you go.
I heard.
I missed the last part, Thomas.
What did you hear last?
That you filed 100 and something or 200 pages of evidence.
It was, okay. My evidence was 132 pages long of my evidence against them. And even though they kept fighting, and the reason I had to go that way is because I missed my deadline for filing my appeal by 1 day because it was a holiday and it fell on a Friday, so it screwed up the whole mail delivery. If that holiday wasn't there, it would have made it in time. They denied my right on an appeal and my right to a hearing because of it being 1 day late. And, I had 132 pages of evidence, and they had nothing against me.
You have to, if especially if you're going, and let me raise another point for you guys, and I think this is important. In my complaint, I went sui juris and pro se. Do you guys know what the difference is? No? So pro se...
your own attorney.
So, pro se basically says, I'm asking the court to grant me a temporary license to practice law and represent myself. That's what that means. Sui juris means I'm coming before the court as a real person representing myself and standing up for my rights. And this isn't asking their permission to practice law. This is saying I'm a person standing up for my rights.
Let me ask you a question then, John, while you're talking about it. I've heard of pro se, but not the other one. Now, when mine all started and I got rid of my attorneys, a lot of my case lagged when the attorney I withdrawed out, because why would you file for custody knowing that there's a PFA? What's wrong with this picture?
Well,
don't you think you would fight the PFA first? No, this idiot wanted to try to go for custody with a PFA there. So anyway, when he withdrew out of my case, and where it all lagged and my headache started, was
the whole purpose is to generate billable hours. That's why. it's to deprive us of our rights and drag out the litigation. So that's why.
But I mean, even when I tried doing it after he withdrew being pro se, they wouldn't do it. I had to wait for the appeal paper. Well, basically, I had to let the hearing go by itself and then file an appeal off of that.
Yeah. Walking in with these guys is next to impossible. But I'll give you guys some ideas of things that I do that I think kind of throw them off guard.
How do you say sui sure? I mean, how do you spell it?
Sui juris.
Oh, sui juris. Oh, okay. I'm okay. I misheard you. Thank you.
This one I just filed in the Sixth Circuit. Petition to discipline attorney misconduct. And I'll tell you why this one is good. And I think there's under the Sixth Circuit rules of appellate procedure, there's Rule 46, and Rule 46 in the Sixth Circuit, it's the same rule in all the circuits, and it says that if an attorney engages in and violates ethical rules, the court may impose discipline. That's what it says. The purpose and the intent of why they have that rule in there, does anybody want to guess? Okay, this is understanding more about why we are where we are. When attorneys first come out of law school, they often come out with the intent of representing their clients to the best of their ability and ensuring justice is served. That's how these guys come out of school. And that's why they went to school, is they want to fight for justice. They believed in it. But when they walk into a courtroom and a judge is jerking their client around and they say, you can't do that, and that attorney files a complaint against the judge, or that attorney argues too much and bucks the system, then that attorney gets reported to the Board of Professional Responsibility, and they say he's bringing the judiciary into disrepute and he needs to be disbarred. And so they pull him into a closed-door meeting with the Supreme Court, and they say, you know, young man, young woman, this is not how the system works. You need to play along, and if you don't, we're going to yank your bar license, and you'll need to figure out some other way to pay for your student loans. That's how they keep these guys in line. And once they start down that road, then, you know, a lot of these guys are on cocaine, or they have substance abuse addictions, alcohol, whatever, because they too are also trying to deal with having to justify their actions, and then they start enjoying the money that comes along with it as well. And then they get caught up in the whole system, and it just perpetuates itself. And then they get into positions of power, you know, 15, 20 years down the road, and they've been indoctrinated into the system of corruption. So that's how it perpetuates itself.
So this is like the self-serving agenda that happens with the addictive culture that we live in. It's kind of indicative of our culture, wouldn't you say?
So now, go back to that Rule 46. The court may impose discipline of an attorney who's in violation of ethical rules. And remember, the ethical rules say you can't bring the judiciary into disrepute. So now, why do you think the appellate courts have that rule? It's because when they're bucking the system, they say you're in violation, you're bringing disrepute to the judiciary, you're disbarred from the Sixth Circuit. Get out of here. You're not allowed to argue here anymore. That's how they control these guys, right? But I used their rules against them. And I said, if we look at the rules of professional responsibility, it says that legal profession's relative autonomy carries with it special responsibilities for self-government. A lawyer should aid in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and the public interest in which it serves. And so, my argument is these guys lied in their appellant briefs to try to gain advantage over me. They just flat out made false statements in their appellee briefs. And I said, not only are they not aiding in the securance of observance of these rules by other lawyers, but they're enabling it by making false statements to an Article III court, and they should be disciplined. That's what your rule says.
John.
Yeah.
So let me ask you another question then on that line. I know in my particular case, and I even put evidence out there, and it's like it was okay. Part of my evidence was their allegation that they put against me, and their facts weren't matching on different documents. Like the one particular one was mentioned on 4 different documents at 4 different times, and when I put that in there,
So you file a motion and say, their own facts don't agree. They're liars.
but then they didn't allow me to testify on it. They're not allowing me to testify. They're not giving. I haven't had a hearing on this one since day one.
So one of the things that I did in my case, and I think this is absolutely critical, and it depends on the state you're in. In Tennessee, we do not have recorded court proceedings. We do not.
Neither do we.
We do not have court-provided court reporters. If you're going to have a court reporter, you got to pay for it yourself. I've made sure in every single. I will not walk into a courtroom without my own court reporter. I will not.
Okay.
And so you say, Your Honor, I would like to present this evidence, and he says, no, you can't. And you say, Your Honor, may I make a statement for the record? I believe that you're violating my right of due process. I should have a right to present evidence to this court, and respectfully, I'm complaining that you're denying me my rights. And he may say, no, you can't make a statement for the record. And then you say, Your Honor, may I make a statement during break for the record?
Okay, now here's my next question. You said you had a reporter go in. What happens if they would wouldn't allow them to go in? Because I know a lot of times they won't let anybody in there unless it's to do with the case because of their bull crap.
I've never heard of the court saying that a certified court reporter cannot attend proceedings.
So you would need a certified court reporter to attend that. Because I've even tried to get somebody who was certified disabled representative to come into the courtroom with me. She's a disability advocate, and the judge wouldn't even look at her paperwork. We're in this court system where they don't care even if you have the proof to show that these people are qualified to be here.
If you walk into a courtroom with a certified court reporter and the court says that court reporter is not allowed in the proceedings, you say, I would ask for a continuance, or you'll say, if you're going to force me to be here, it's under protest, and then you take that and go into federal court and say, this is ridiculous, but I can't have a court reporter present. And you file an emergency motion to stay state court proceedings and file a temporary restraining order and injunction against the court to order them to say, he needs to have a court reporter there, and you can't not do that. That would probably be the route that I would go.
All right. All right. Thanks, John, for clearing that up.
But this document here, this petition for attorney misconduct, I really caught them off guard with this one. I called up. They actually filed it into the record in my case. I'll give you guys an example of what I'm working on here.
Would a case of attorney misconduct also include like a failure to communicate? Would that be considered?
Yeah, read the rules. Here, let me give you guys a quick tour. So in most of these are under Supreme Court rules is where you'll typically find the Code of Judicial Conduct, and in Tennessee it's Rule 8, Rules of Professional Conduct, and this is where I got that preamble where it says the legal profession's relative autonomy carries with it special responsibilities for self-government. That's out of the preamble. It's in every state. They're all the same. And then I'm going to hit Control F and look for misconduct. Let me bounce through here real quick. Reporting professional misconduct. And then it has a lawyer who knows that another lawyer has committed a violation of the rules that raises a question to that lawyer's honesty, trustworthiness, or fitness of the lawyer shall inform the disciplinary counsel. The lawyer that knows a judge has committed a violation shall inform the Board of Judicial Conduct. And that's the same for every state. And these are the things that we have to do, is file these complaints. And when these oversight agencies don't do their job, then we sue the state, we sue the oversight agency, and we evidence it in the record. Even though the probability of winning those cases is small, we get it in the record. And you don't give them an easy win, you make them work for it. You know, when you don't complain, you're just giving them an easy win and they just keep doing the same shit, right? You got to fight back against these guys.
We're trying to keep professional conduct here, John. I just want to bring that to your attention, because we do have parents out there who want to learn, absolutely, and may have children in the room when they are listening to this. So
I'm an old Marine and it comes out in me sometimes.
All right, thank you.
I apologize and thank you for bringing it to my attention. But you know, when I went into the Sixth Circuit with this, I called the case manager because I was going to show you guys. They actually entered this into the docket in my case. Let me jump in there real quick. And this is also really important. So this is PACER, Public Access Court Record System. If you're filing a federal case, you've got to sign up for PACER and check the docket every single day. One of the tricks that they use is they'll file an order that you only have 14 days to respond to, but they don't mail it to you. And so I take in mine, I actually take screenshots of the docket. I'll show you an example of what I do. So that way, if they try to backdate something, and they're known for that as well, I can catch them on it.
If they don't email you or message you or mail you with it, isn't that failure to notify?
Yeah, it is, but they do it anyway. That's why it takes. So this is I print off my docket report on here, and you can see I save these things pretty regularly. So that way, if they try to backdate something in there, or you know, and then I can evidence it and say, you know,
John.
Yeah.
Now here's something for you. I'm sure they're supposed to, but what happens about if they don't even date something?
if they don't date it,
Mm-hmm.
they always date it. They have to.
Or even have a stamped signature, like not even
Mine,
a real.
my original thing when it started, I wish I would have knew this as much as I did when this started. My original document does not have a judge's signature and is not dated. It says as per verbal order, and it's signed and initialed underneath by the attorney that represents the agency.
Yeah, I challenge it as a void judgment. It's not a valid judgment unless the judge signs it.
Okay.
But so I call the Sixth Circuit rule for petitioning for attorney discipline. It says that it's filed under seal, and so I get notification when anything hits the docket, and so I called up the case manager, and she's like, hold on just a minute, and she sent me over to the chief deputy clerk. So in the Sixth Circuit, there's 14 case managers. Each case manager oversees about 200 cases. And with those 14 case managers, there's also an en banc coordinator, and there's also a clerk for attorney admissions and attorney discipline. So that's like 16 clerks, all overseeing 200 cases. And then there's a chief deputy clerk over the top of all those guys, who at any given time is overseeing about 3,000 cases, right? So they forwarded me over to the chief deputy clerk, and I was like, hey, I didn't understand. I thought this thing was going to be filed under seal. I was a little surprised that it hit the docket. What's up with that? Am I going to find, what's the process here? Explain this thing to me. And she said, well, we've never had one of these before. And I was just like, well, that doesn't surprise me, because the good old, they will not hold each other accountable. They just won't. So the purpose and the reason that they have that rule is to get rid of people who are bucking the system, right? Why use their own rules against them? And said, and back in my document, I said, the rule says that the court may impose discipline. But when we look at the code of conduct for federal judges, it says you should impose discipline. And let me give you an example of what I'm talking about.
On our site, the coalitionforprotection.com, we have a page that shows what the violations you can sue judges, what amount, and it was decided by the Judicial Committee, I think the National Judicial Board, what these fines would be for the violations that are listed, whether Rico violations, civil rights violations, human rights violations, trafficking, human trafficking violations, all of these violations, and how much money you can sue a judge or any other legal representative or in these cases. And so it's amazing that they are not being held accountable, even with this system set up.
So so Sixth Circuit Rule 46, it says the court may impose discipline. But I said, well, yeah, you may impose discipline, but the code of conduct for federal judges, and by the way, if you just go Google that, comes right up from the U.S. Court's website, and then that's the code of conduct for judges. And so in there, it says the judge should maintain and enforce a high standards of conduct. And then it goes on, and it uses the conjunction and, stating, and they should personally observe those standards, which means judges should not only adhere to high standards of conduct, but they should enforce high standards of conduct in those that come before them. And then the canon says the judge should at all times act in a manner that promotes public confidence in the integrity and the impartiality of judicial proceedings. Well, if they don't address an attorney who lies in their appellee brief and makes false statements, that doesn't promote confidence in the integrity of proceedings, does it? And so you should act. The canon requires it. A judge should hear matters assigned and should maintain order and decorum. Orderly proceedings require that facts of the case be truthful. They've so misconstrued facts throughout their briefs that they're deceitful, compromising the integrity of proceedings. Decorum is defined as that which is proper, acts demanded by custom, appropriateness, deceit, and dishonesty are contrary to what decorum is. A judge should require similar conduct as the subject of judges' control, including lawyers, to be consistent with their role in the adversary process. It's not dignified, nor respectful, nor courteous to engage in deceit and dishonesty so as to gauge advantage over other litigants. So I put these judges I put their back to the wall, and I said, intending no disrespect, but the counsels for the defendants in this case have put the court in the unfortunate position of imposing discipline against respected members of the legal profession, or violating the code of conduct for federal judges. We'll see what they do with that. But this is how we have to fight back with these guys, is use their own rules against them and say, here's what the rule says. Are you going to follow it or not? Going back to that story about calling the case manager who put me through to the chief deputy clerk, when I said, well, am I going to be notified if this thing is filed under seal about what the court does or doesn't do here? And she said, well, you've asked for specific relief as sanction for their misconduct. You've asked that their appellee briefs be stricken from the record. So yeah, you'll be notified. But what impressed me about that is here's the chief deputy clerk who's in charge of 3,000 cases, and she's familiar with my petition for attorney misconduct, so much so that she knows the specific relief that I was asking for. And so I think it kind of got their attention.
Yes. Wow.
So that's, when they come out and say, well, this rule, I'll give you another example. In the Sixth Circuit, do you guys know what case management is?
Yep. Yeah.
So there's a rule in the Middle District Tennessee District Court that says any case in which one of the litigants is pro se is exempt from customary case management, customized case management. Customized case management is there to provide cost-effective judicial proceedings that are efficient and timely. That's the purpose of customized case management. Why isn't a pro se litigant afforded that same deference? Don't I have the same right to cost-effective and efficient proceedings as a legal professional? Of course I do. And that's a violation of the Equal Protection Clause. And that court rule is unconstitutional. And so, when they come at me with that crap, I don't, most people just go, oh gosh, I don't get customized case management, rules say it. Well, I say, well, the rule's unconstitutional. And I do the same thing with statutes. And I say, these statutes are unconstitutional. That's how we fight back. So I'm going to close out here because I got a lot of writing I got to do, and I yak a lot. And you guys have been really gracious for listening to me for so long.
And this is just such awesome information, really, John, because it helps a lot of parents around the country who are confused and not able to read everything, specifically like the step-by-step process. So it's great
That's
been able to help. Yes.
But that's the whole point. That's what they want us not to be able to read it all.
I know, and so it's great to have someone like John
But
here who's got the experience and has been doing this for a long time, and you know that we all start learning from not just reading, because I mean, yes, you have to read, absolutely, but it's good for parents to be able to have a little bit of a tutorial, and that's what we're having here. So thank you.
absolutely, but I mean, holy hell, my head's just spinning. It's gonna blow up tonight. Man, I thought I was good with it. He just made me look bad.
You know,
But John, I sent you a message.
sorry, go ahead.
Go ahead.
You know, there's no statute of limitations on filing a complaint against the judge. So if you have proof that your rights were violated, file a complaint. And when it's dismissed, bring a cause of action against the state and that judicial oversight agency. And at the same time that you do that, challenge these unconstitutional statutes. And anybody's interested in doing that, I can walk you through and help you find where your statutes are and how to analyze it and say, is this constitutional or not? Because it's not that hard.
Hey, John. Actually, while you're just saying that, I did send you a private message on Facebook, and I wanted to actually see if you had time to kind of do like go over and help that way.
Here's where I'm at. I've got another cause of action that I'm going to file in the next month or two against the state, another action against the state of Tennessee, whole new brand new lawsuit. I've got a case in the Sixth Circuit, and then I'm working on a case in the Supreme Court as well. So my time is like buried. I'm happy to spend time like this to walk people through the process. I do not write briefs. I will share my work, and I have templates for all of my work. The only thing you need to do is take out my facts, change the cover page, plug in your facts, and it usually works.
Yeah. Well, no. It wasn't just that, John. And as I told Lyra and Mim, I told as well. I just actually started my own platform out there to so we can get it out there. And I mean, John, with how much knowledge you have, or anybody in this room for that matter, if you think it's something to help somebody, let me know. That's what it's there for. I'll give it to you to do it. You know, I'm not going to ask questions.
And I have the templates for how to file these complaints. You know, again, swap out the cover page, change the facts, and $300, and you're on your way. And if nothing else, and I'll tell you, this was absolutely profound for me. When I went through this process, it destroyed me emotionally and financially, as probably you guys have experienced too. I started drinking a lot. I would wake up at like 6 o'clock in the morning and have a glass of wine just to take the edge off. Because I actually made an argument in my brief that for these judicial oversight agencies to not take action is no different than a law enforcement officer watching a gang rape and taking no action, because that's what it feels like when you're betrayed by your government. It feels like, and the symptoms that I went through, if you go, the women on here can probably understand it far better. But the symptoms that I felt are the same symptoms that describe the results of rape. And it's just wrong. You cannot walk into the courtroom and tell the judge you're violating my rights, you're perpetrating crimes against me, you're an evil person. You can't do that, because they're going to throw you, they hold you in contempt of court and stick you in jail to shut you up. But in your federal pleadings, you can say whatever the hell you want, as long as it conforms to the rules. And so, I often say these guys are confidence men, they're oath breakers, and that has been so liberating and so healing to me, to be able to say to them and confront them and say, you violated my rights and what you're doing is wrong and you're harming not just me, you're harming the country. And I laid out big scholarly argument on how this adversely affects the GDP of our entire country, because they typically target high-earning individuals. And when they go after us, we can no longer do our jobs the way that we used to do. And so the best and the brightest amongst us who innovate business and create jobs are debilitated that we can't do that anymore. And that contracts the GDP of this country. Beyond that, they take away our ability to provide for our children. And that has even longer consequences. And these kids that are alienated from their parents, that do not have the financial support of the family unit anymore because the lawyers have extorted all the money out of the family, those kids are going to be affected for the rest of their life. And so the downstream from this problem is huge. For me to be able to say that in court and in my pleadings to them, it's very healing. And so that's another aspect to taking these complaints, is it gives you a voice. Whether you win or not, it gives you a voice, and it gives you a chance to evidence in the record what's going on. So I encourage people to fight back. You know, file those complaints against the attorneys with the with the Board of Professional Conduct, file the complaints with the Judicial Oversight Agency, and then take them to task in federal court when they get dismissed.
And that's the way to go. And thank you so much, John, for joining us tonight. And I would love to offer the other part of the lesson you were talking about before as another meeting. If maybe we could set up another day for that, that would be great.
Sure.
And I want to thank everybody for joining tonight. I have sent you my email address. I would love to get those templates, because I am in that process right now of going and going in front of the Judicial Review Board and going that far up into the federal appeal court and the federal courts. So.
Yeah, me too, John. I'm going to need that too if you have a moment.
Yeah, just shoot me a message, and I've got, you know, complaints to file against attorneys in state court. I've got complaints to file against judicial oversight agencies. I have complaints against the judge that violated your rights. I have complaints from Rico. So, you know, and I think that pretty much covers most of what everybody goes through.
Yes, indeed.
And beyond that, I'm going to show you guys real quick here, this last one, to give you an idea of my work.
And I mean, John, another thing, if you have any templates or anything like that, I'll even, you can tag me in them so they're on my page so we can get, you know, the information out there to the people that don't know what to do so that we can put a stop to this, you know.
Yeah.
Because you're, like you said, you're only one man, and you know what you're going through. If you have 20 people coming to you at once, of course you're not going to be able to get your stuff done.
And I would be happy to share it on the coalitionforprotection.com website. That's the website we have for helping parents, guiding them, and giving them resources, and being able to share the load here, because there are thousands and thousands and thousands of parents that are experiencing the same civil rights violations and not knowing what to do. And so, yeah, this is great.
But this is my docket for my Rico case on here. I've literally written thousands of pages of briefs into this. So when you file these complaints and they file a motion to dismiss, I've already got the responses done. You don't need to do any legal work. All of the legal arguments, everything I've already researched and done it for you guys. And I kicked their butt. This same chief deputy clerk in the Sixth Circuit, she said that my legal work would stand up against any attorney, anywhere, anytime.
Wonderful. That's the kind of work we need to be getting out there, getting these judges and attorneys to become accountable and start behaving properly.
Another one, and maybe you guys can help with this, but this is another project that I want to work on, and I'm trying to find people across the country. I want to bring a lawsuit, the people of the United States versus the 50 United States is the title of the case. And there'll be three main causes of action: unconstitutional laws, the fact that we cannot enforce our rights. You know, you sue a judge, they say, oh, judicial immunity, sovereign immunity. Try to sue the state, they say sovereign immunity. You try to sue the governmental entity, they're like, oh, well, we got a statute that provides immunity for them too, so you can't sue them. Well, how do you enforce your rights? You know, Marbury v. Madison, I think it's 1908, where there's a legal right, there's a legal remedy. We don't have a legal remedy anymore. We have no way to enforce our rights. And so that's a really good cause of action, I think. And then the last one. Yeah.
Just on that note, if you wanted to, like I said, I have a radio station. If you had time and were free, and we wanted to get this information out, like about the whole class action, I'll be more than happy, and we can do it just to get it out there, you know, and get it out there faster.
Yeah,
We're going to
like I said,
publish this meeting, Thomas. We're here to talk about what John is presenting, and I know that you have a podcast, and we want to support you in that. But tonight we're finishing up with John's presentation, and I'm sure that you two can connect at another time. Thank you.
But what I want to do is I want to find one litigant in each state who will be the lead pro se litigant, because we're not going to get an attorney to work with us on this. One person from each of the 50 states representing the people of that state. And we file this as an original jurisdiction action under Rule 17 of the Supreme Court rules and go straight to the Supreme Court, skip all the other crap. And say, you know, we can't enforce our rights, these states, and we would list out each individual state and say that they have these unconstitutional laws and we want them rendered void. And then that these states don't provide any oversight, and we refer back to that auditor's compilation report showing that they don't provide any objective oversight of the judiciary. And then along with that, we would do amicus briefs that each of these litigants from across the country would go out and gather stories and put in, you know, a little 2-paragraph, this is how my rights were violated, and include that in amicus brief to say, here's what the hell you guys are doing. This needs to stop. You know, this is like gotten way out of hand. We're right back to where we were, you know, 200 plus years ago when we separated from England, because that's exactly where we are right now.
And I have a question for that as well. You know, when you put this together state by state, we also have this issue of lack of oversight in Department of Children and Family Services and Social Services. There is no independent oversight there either. So there's judicial obstruction going on even at that level. Can that be also considered in this?
If you want to take the lead for California and include that in there, absolutely, why not?
Because I mean, and it's not just in California that this is happening. It's nationwide. The lack of oversight in social services, CPS, DCSF, you know, whatever they want to call themselves, and they change their name when people start filing too many suits against them for malpractice and maltreatment, civil rights violations.
So when we go into the Supreme Court and we say, here's 50 people from across the country representing all of the people of their respective states, And here's these unconstitutional laws that are repugnant to the Constitution. And here's the facts showing that there's no oversight of the judiciary. How does the Supreme Court say, nah, we don't want to grant cert on that one?
Right.
You know, without evidencing their own corruption, you know?
Okay. Okay. Well, that sounds like we're on board with that for sure. And, you know, I would love to have you come back and talk more about that. And
I'm not done from there. There's another way. Under the USC, you can petition Congress directly. So when the Supreme Court
Ooh.
says no, then we go to Congress.
Okay.
And when Congress says no, I'm working on a complaint against President Trump, and maybe we'll get his attention. And I don't think he really cares for judges too much. So maybe he might be interested in trying to fix this problem.
Now, a question that comes to mind, because there is the Human Rights Tribunal that has been collecting jurors from every state for claims of human rights violations filed in parental rights violations cases. Would this also be something you would consider as if President Trump were to deny himself the?
We have to, you know, freedom doesn't come free. You know, our founding fathers fought for the rights that we have, and they've been taken away. The states have usurped and subverted our rights, and we're being subjected to absolute despotism because there is no means of redress anymore. And so, you know, we got to think out of the box, and we have to try things that haven't been tried before. You know, if you keep doing the same thing, you're going to get the same results. So you got to do it differently, right? So
doing things the same way over and over again, expecting different results is the definition of insanity.
Definition of insanity, right? So, you know, I'm open to anything that is going to affect change, because I just don't want anybody to go through what I went through. And you know, in my case was just about property, but as a former Marine who served this country for 8 years and lost friends defending the Constitution, it's dear to me. You know, it means a lot to me. And for these guys to just throw that away is like, it's like them spitting on the corpses and the broken bodies of people who have sacrificed themselves for this country. And that's, you know, that's why I'm in this fight, is because it's disrespect. It dishonors the memory of the people who gave us our rights. And it hurts to the bone, and I don't want anybody else to go through that, you know. You know, I'm tough, I can fight back, but a lot of people can't, and they commit suicide accidentally, on purpose. You know, they fall victim to substance abuse. It's got to stop. You know, that's historically, that's how nation states and empires have fallen. There's always corruption is an underlying cause. You know, and that's why, you know, there's other factors, overextended military, economic disasters, things like that, but there's always corruption because the infrastructure isn't there when the military is overextended or when there is economic disaster. And the system can't support itself when there's all that corruption there. That's where we are right now. You know,
right.
just, you know.
Well, and we're here at the Parent Advocate Network looking for ways to make everything better for everybody. Oh, look at that wonderful pooch. You know, that we want parents, families, children, aunts, uncles, grandparents, all to be involved in community building and creating a way of life that is more wholesome and humane, and bringing humanity back to the human race, because it's so far from that. And yeah.
I tell you, one thing I really believe is that these people are not evil to the bone. Yin and yang, there's good in all of us and there's bad in all of us. And, I just try to hold a mirror up to them and say, this is who you are. This is what you've become, and this is the harm that you cause. And let's work together and try to find a way to stop this.
Let's work together. United we stand. And with that, I would like to bid you all good night. It's been a great 2-hour conference. We do this every Saturday from 7 p.m. to 9 p.m. I also am open to having one-on-one interviews at your scheduling preference. You just contact me privately. I am on Facebook as Lyra Jubb, and this is what we want. We want people to be connecting and starting to bring the solutions to the surface and helping parents, families, everyone to maintain, regain, and sustain their rights as human beings here in this country and in this world. So thank you very much, John.
All right, y'all have a good night.
Yeah, you too.
Thanks for having me on. Thanks for listening so much.
And please come back. I would love to talk more about the other projects that you're working on, this national suit, and I want to be a part of that. So
Awesome. Good.
Thank you.
All right, y'all have a good night. Bye.
Have a good night, everybody.